The Australian taxation system is a subset of the Australian legal system. The overarching rules regarding the Australian legal system are dictated by the Australian Constitution. Australia has a federal system of government with two main levels of government, being the federal or national government and the state and territory governments. A third level of government are local councils, which are given their power by the state or territory government. The Constitution gives and sets out the division of powers between the federal and state governments and gives courts their powers. It also specifically states the areas that the federal government can legislate in. Under the Constitution, there is the important principle of the separation of powers. Under this principle, power is separated between the legislature, the judiciary, and the executive. The legislature is the elected parliament that passes laws. The judiciary is the court system that applies and interprets the law. The executive is the Governor-General, government departments, and executive authorities, such as the Australian Taxation Office, which administer the law. The federal parliament contains two elected houses. The first is the lower house, being the House of Representatives. The second is the upper house, being the Senate. Income tax, the goods and services tax, and the fringe benefits tax are all governed by the federal government. In general, such tax laws have two main sources, statute and case law. The first main source of law is statute, also called legislation, which is what Parliament has passed as law. The power to raise taxes in Australia is established in the Constitution. For example, Section 51(2) gives the federal government power to make laws relating to taxation. Section 53 states that taxation bills must originate in the lower house of Parliament rather than the Senate, and Section 55 only allows a law dealing with tax to impose a tax and not any other subject matter. For the federal government to pass laws, a bill needs to be written, which is then passed by the majority of both houses of Parliament and then receives royal assent from the Governor-General. The second main source of law is case law, which arises through the decisions of the courts. The reason case law forms part of the law is because of a legal principle known as the doctrine of precedent. Due to this principle, judges will generally make decisions that are consistent with the decisions of judges in earlier cases. However, judges are only obliged to follow earlier decisions that are made by courts higher than them in the court hierarchy. When judges are not obliged to follow earlier decisions of other courts, there is still a tendency for them to do so to varying degrees. The Australian court system hierarchy has the High Court at the top, followed by the full bench of the Federal Court. Below this is the Federal Court with a single sitting judge. There is also the Administrative Appeals Tribunal, which, as its name suggests, is a tribunal rather than a court. Its decisions do not bind any judicial body. Lower courts are only bound by statements of higher courts when such statements are ratio, that is, the court's reason for its decision. This compares to the obiter, which is something that is mentioned by the way to influence rather than bind future court decisions. For instance, assume that taxpayer A appeared before a court and the court found that A's receipt was assessable. The reasons that the court stated that the receipt was assessable would constitute ratio. If the court then went on to comment that the receipt would not be assessable if certain facts were different, then this would constitute obiter. In general, as far as tax law is concerned, the courts will apply the law and make decisions in two broad situations. Firstly, assessing the facts of a case against existing case law. For example, courts over time have dictated what ordinary income is. So, if a case decides that a certain gain constitutes ordinary income, this will form part of the law. Secondly, interpreting and understanding specific statutory provisions. For example, the tax legislation states that specific gains are assessable and they will constitute statutory income. In a particular case, it might not be clear whether a situation falls within a specific statutory provision, and if this goes before a court to decide, the court's decision will form part of the income tax case law. As far as administrating tax law is concerned, the ATO is the government agency for administrating the federal government's tax regimes. The Commissioner of Taxation supervises the running of the ATO and can delegate authority to other employees working there. To recap, the Australian Constitution is the governing document of the Australian legal system and therefore the Australian tax law environment. Through the separation of powers principle, it considers the respective roles of the Parliament, the courts and the ATO. Tax laws are both documented in statute and arise from cases, and it is the ATO's responsibility for administering the federal tax regime.